Well, good afternoon. Thank you for joining us today. My name is David Russell Jensen. My Tlingit name is Shakaguk. Today is Dr. Walter Soboleff Day. We acknowledge Dr. Soboleff's significant spiritual and cultural contributions to Alaska Native history. Sealaska Heritage is committed to providing accessible community programming, but none of our programs would be possible without the support of donors. You can contribute online at sealaskaheritage.org/giving. Our lecture today is presented by Chris McNeil on Alaska Native tribal status and sovereignty. McNeil will examine the status of Alaska Native tribes as federally recognized entities and key statutes, including the Indian Self-Determination and Educational Assistance Act. McNeil will also provide insights into the landmark Yellen versus Confederated Tribes of the Chehalis Reservation case and its implications for Alaska Native Corporation's legal status. McNeil served as Sealaska Corporation's president and CEO for 13 years, following executive management roles and a career in law, academia, and tribal governance. There will be an opportunity for questions at the end of the lecture. If you're here in person, please silence your cell phones, and welcome Chris McNeil. Thank you.
Well, thank you very much. It's a great pleasure to be here. My Tlingit name is Chaguni and Gawats, and I also have my Uncle Judson's name, Shaka Kuni. I'm Dakhlawadi, and he was the former chair of the Sealaska Heritage Institute. So it's quite a pleasure to be here, to be able to discuss the Chehalis case and some of its implications insofar as Alaska Native law and policy is concerned. This review concerns what constitutes an Indian tribe under federal law. This was litigated and decided in the case of Yellen v. Confederated Tribes of the Chehalis Reservation, and this is otherwise known as the Chehalis cases. I'll reference it in this discussion. What was this dispute about? It takes a little bit for us to think about what was going on, when this happened. This happened during COVID-19, and it already feels like there's a lot of distance between us and COVID-19, but in 2024, our main concern about COVID is just to be sure that we get a vaccination, and if you get COVID, it's not likely to be a really, really big problem like it was then, because then in 2020, if you got COVID, there's a fair chance that you might die, and it was a very different story at that time because there was no vaccine. The various states declared emergencies. There were you may remember the stay-at-home order. So 43 states governors issued those, and it kept people in place for the better part of a year. And so this was really a combined public health emergency and also an economic emergency for the entire nation, and it really compounded it. And there created a lot of uncertainty, not just in individuals, but also in the government. And the state of California was actually the first to order the stay-at-home order in March 2020, and by a year later, 42 states had done so. So Congress looked at this, the president looked at this and was thinking about, how do we provide a remedy? How do we stabilize the country? And what they did is the president intervened in the economy by creating what is known as the Coronavirus Relief and Economic Securities Act, and that's known as the CARES Act. And what that did is it was enacted on March 27th, 2020, and basically provided $2.2 trillion to inject into the United States economy. That was passed in in law almost instantly for the way legislation works, and it provided direct payments, and one of those payments was to adults who were adult citizen taxpayers and would receive $1,200, and the families would receive more. The CARES Act itself provided funding, direct funding for tribes as Indian tribes. And whether or not the Alaska Native Claims Corporation were eligible for these payments was disputed by other tribes. And they notified the Secretary of the Treasury, they notified the Congress, and finally they filed a lawsuit, which became the Chehalis case. In the district court, there was a decision favorable to inclusion of the Alaska Native corporations in these benefits. Was appealed to the appellate court, where the Native corporations lost, and then it was appealed to the United States Supreme Court. And basically, there were a series of tribes that opposed the inclusion of Alaska Natives in the case. And the question presented to the Supreme Court was whether Alaska Native corporations are eligible to receive any of the $8 billion that was allocated to tribal governments under the CARES Act. And it's a very straightforward question. And the case itself, I wanted to read the very short section of the case that is the most succinct statement of it. And they said that under the CARES Act, a tribal government is a recognized governing body of an Indian tribe as defined by the Indian Self-Determination and Education Assistance Act. ISDA in turn defines an Indian tribe as any Indian tribe, band, nation, or other organized group or community, including any Alaska Native village or regional corporation, as defined or established pursuant to the Alaska Native Claims Settlement Act, which is recognized as eligible for the special programs and the services provided by the United States to Indians because of their status of Indians. So that's the core authorization. And there was a sequence within these definitions that it's worth looking at, because the Title V of the CARES Act stated that the term tribal government means a recognized governing body of an Indian tribe. And then there was another reference that said that the term Indian tribe has a meaning given to the term in Section 5304E of Title 25, and that section is the Indian Self-Determination Act that it cross-references. And further, the specific definition of an Indian tribe in the Self-Determination Act is an Indian tribe as any Indian tribe, band, nation, or other organized group or community, including any Alaska Native village or regional or village corporation, as defined in or established pursuant to the Alaska Native Claims Settlement Act, which is recognized as eligible for special programs and services provided by the United States to Indians because of their status of Indians. Well, there were two competing textual interpretations of the definition of Indian tribes. The Secretary Yellen and the ANCSA corporations, even the state of Alaska, the congressional delegation had one view of that meaning. The tribes, on the other hand, had another idea about this, and they said that in addition to the ISDA statutory definition, the one that I just read to you, that in the definition of an Indian tribe, there's a term of art usage of the term Indian tribe that effectively limits who is an Indian tribe. And they argued that the ISDA phrase recognized as eligible meant that the ANCSA corporations also had to be a federally recognized Indian tribe. In 1975, when ISDA was enacted, They reasoned that by Congress including the term recognized in ISDA, it imported the term of art federally recognized Indian tribe. The current repository of Indian tribes is a federal List Act of 1994, and ANCSA corporations are not listed in the List Act. The court in Chehalis disagreed with the Chehalis tribes' arguments, and they said that the plain meaning of an Indian tribe under ISDA provides that ANCSA corporations were eligible for the CARES Act funding. As a factual matter, the ANCSA corporations were established pursuant to ANCSA and thereby recognized as ISDA as eligible for ISDA benefits. The court further conclusion that even if ANCSA corporations did not satisfy the ISDA recognized as eligible clause, they still would be qualified as an Indian tribe. Now that had consequences, that decision. So that was the case. Native corporations litigated and defended and won the case, but it had consequences. And what it meant, and I want to give you a couple of examples of what actually happened. So the ANCSA defined the regional, village, and urban and group corporations as Native corporations under ANCSA. Now it's assured that the Native corporations qualify for all of the ISDA programs. They also qualified for the 117 additional Indian programs of general applicability that refer to the ISDA definition of an Indian tribe. The Chehalis case clarified that ANCSA corporations qualify for a much broader range of Indian programs than ISDA itself. I'm referring to those 117 other statutes. It's also the case that there are numerous federal Indian programs that use the definitional language that is not included, that does not include ANCSA corporations. So specific technical amendments would be necessary to conform them to the ISDA definition in the future. And as an aside, there are other federal Indian programs for which neither Alaska Native tribes nor ANCSA corporations qualify because there's no applicable Indian country in Alaska. That's a separate issue from this, but it shows the complexity of the issues that we're working with. The Chehalis case also provided clarity that the Department of Interior is authorized to enter self-governance compacting with ANCSA regional corporations. This is totally new. This is a totally new application. In September 2024, the Department of Interior entered into a self-governance compact with Atna Inc., an ANCSA regional corporation, and as an Indian tribe as defined under ISDA. This is a landmark self-governance compact agreement between the ANCSA regional corporation and the Secretary of the Interior. The compact has no expiration date, but it can exist for as long as allowed under federal law. The compact scope concerns the implementation of certain specific programs, functions, services, and activities previously administered by the Department of the Interior. The subject matter of these programs, functions, services, and activities includes the administration of ANCSA Section 17B easements across Atna lands. So it's specifically tied to the implementation of ANCSA in a way that the department, BLM, previously had responsibility. The DOI compacted to protect all the same responsibilities to Atna as it would have as a federally recognized tribe. This compacting agreement is a template for other regional corporations and other Native corporations to follow if they so choose. Another very important consequence of the Chehalis case is that it clarifies the meaning and implementation of tribal organization as defined under the Self-Determination Act. Under ISDA, tribal organizations can be created by ANCSA corporations and also qualify for federal programs that use the ISDA definition. A tribal organization has all of the same rights and responsibilities of the authorizing Indian tribe, except as provided in the agreement between them. So a tribal organization basically stands in the legal shoes of the Indian tribe that created them. These are really very powerful authorities. Sealaska Heritage Institute was established by Sealaska Corporation and is thereby a tribal organization under the Indian Self-Determination Act. There were also other immediate consequences of the dispute, of the Chehalis dispute. The tribes went to court, but they also successfully lobbied to exclude Native corporations from the next bill, which was the ARPA bill, provided an even greater number of benefits to the American public. The part that dealt with Indians injected about $31 billion into Indian country. And of that, $20 billion were direct payments. And it's that $20 billion for which ANCSA corporations were excluded. And this was to the detriment of Alaska natives writ large, lost opportunity for receiving several $100 million. There's been no formal accounting of that. That is my estimate. I think it's actually quite accurate. Among our other arguments, the Chehalis tribes argued that the inclusion of ANCSA Corporation would constitute double dipping, because they're saying, okay, you have tribes, you have Native corporations, they're going to get this money twice. And so they made that argument to the Congress. But what actually happened was the opposite, because the allocation formula used by the Secretary of Treasury worked to the extreme detriment of Native corporations and Alaska Natives generally. One element of the formula that was used by Secretary Yellen is that it counted the total number of tribal enterprise employees, or FTEs, full-time equivalents. In 2014, it was established that Indian gaming, no Indian gaming in Alaska, lots of Indian gaming stateside, they have about 635,000 full-time employees employed by the Indian gaming tribes at a cost to the corporations, of the Indian gaming tribes, about $32 billion, and that's from 450 federally recognized tribes. And that didn't even count the FTEs from other tribal enterprises, including 8As that they have stateside, and tourist and agriculture and all kinds of other things that they have. So it created quite an asymmetry under the program, under the ARPA program. In contrast, virtually all of the enterprise employees for Alaska Natives are in the Alaska Native corporations. They're not in the federally recognized tribes, that is the IRAs. And in 2021, it was estimated that the ANCSA corporations had about 15,000 FTEs. So you can see the great asymmetry between, over 300,000 and 15,000. But under ARPA, we were not even able to count the 15,000. So you can do the math and kind of see what happened here insofar as the effect of the lobbying is concerned. The Chehalis effectively messaged that the ANCSA corporations were huge billion-dollar operations that would be getting more than their fair share of these ARPA funds, and that's why that's how they rationalize it. Instead, it turned out that Alaska Natives received a lot more than to which than they would have been entitled under ARPA. And the reason is that the combined Alaska tribal for-profit enterprises are much, the stateside tribal enterprises are much, much larger than the ANCSA Alaska Native enterprises combined. In 2024, just thinking about how big this is, the National Indian Gaming Commission reported the gross revenues from Indian gaming alone is $41 billion of gross revenue. In contrast, if you look at or review all of the Alaska Native Corporation's gross revenue from all sources, it's not more than $18 billion. So it's less than half of the Indian gaming alone. In this case, the exclusion of ANCSA corporations for ARPA was really to the great detriment of Alaska Natives generally. And even though ARPA is an extreme example of the exclusion of ANCSA corporations from a funding formula of an Indian program, it will continue to be a problem if it's not clarified and resolved. The coda to the case, Chehalis case itself, is that it's not over. For the Chehalis and at least some of the tribes that supported them, they've really not accepted the results of the Supreme Court case, and their remedy, and they don't believe that ANCSA corporations should be considered Indian tribes for ISDA or other purposes. So as recently as the last NCAI mid-year conference in October, just a month ago, several tribes objected to the inclusion of ANCSA corporations in a proposal that would authorize Indian tribes to co-manage certain U.S. Forest Service programs. Because of the intertribal conflict and with Native corporations, the proponent of this resolution withdrew it. Therefore, this remains a very important public policy issue, and it's important to resolve for the future. It's not over. But I want to discuss also a bit more about the context of ANCSA and the Alaska IRAs as it impacts public policy. The case, the Chehalis case, and Justice Sotomayor referenced Alaska and by pulling out a reference to the Sturgeon case and pointed out that there's a rule that Alaska is often the exception to the rule in federal law. That observation has exceptional meaning in the context of Alaska Native law and policy. Several of these issues were not necessary to the Chehalis case, but I think it bears discussion here because we're thinking about how do you formulate policy going forward. It's important to understand how the United States achieved jurisdiction to take and settle Indian land claims under the Constitution and including with treaties. It's a long and windy road to the outcome, or looking at the outcome of the side-by-side existence of ANCSA corporations as a federal land claims settlement and the separate recognition of federally recognized tribes under the Composite Indian Reorganization Act for Alaska of May 1936. That's known as the Alaska IRA. And it bears discussion because they were created 50 years apart, basically, and they exist together. In order for the United States to take lands from Indians and Alaska Natives under the Constitution, they must recognize and negotiate with an Indian tribe. Both treaties and congressional legislation are bilateral agreements. They require the representation and presence of, in our case, Alaska natives. ANCSA is not a treaty. It's a constitutionally, it's a treaty substitute. Both Indian treaties and congressionally authorized Indian land claim settlements are both the supreme law of the land under our Constitution. It became apparent in the Chehalis case that the Chehalis group of tribes didn't accept this fact because they always said, well, you have treaties here, they're superior, got native corporations and ANCSA over here, and that's something less. They went out of their way to deride the ANCSA corporations as merely private corporations that were authorized under Alaska state law, and they're not an Indian tribe, even when the Congressional Act stated that it was. Their legal positions asserted that in Chehalis, it were as if the ANCSA, as a law, operated more like a termination settlement, and it was definitely not. There can be little doubt if you in reading the ANCSA congressional findings that ANCSA transferred, that ANCSA lands would not be transferred to Alaska Native tribes as Indian reservations, so that's clear. But the operational provisions didn't prohibit such transfers, and that's in litigation itself right now on land and trust. But the operational, but there are two important facts that support this. In 1971, or by 1971, Congress had extensive experience in terminating Indian tribes. They knew how to do it. In 1953, the House concurrent resolution authorized formal tribal terminations. Between 1953 and 1970, 60 tribes were subject to terminations. And by and that was basically 3 million acres of land that was lost as a consequence, or were subject to it. In 1970, President Nixon, in a message to Congress, disclaimed termination as Indian policy. It was a very important moment for us. And it would have been kind of nonsensical for the President Nixon to disclaim termination in 1970 and then include termination in ANCSA in a land claim settlement in 1971. It was not included. So the question here is, and the importance is that Congress knew how to terminate if it wanted to, and there's very specific language that does termination under federal law, and none of that exists under ANCSA. Instead, ANCSA provided for a continuing relationship between ANCSA, Alaska Native corporations, and what only can be Indian tribes. They really can't be anything otherwise. Otherwise, there cannot be this type of constitutional jurisdiction to be able to take the lands. Congress' most definitive statement on its relationship with ANCSA Corporation was in the Alaska Native Claims Settlement Amendments of 1987. These are known as the 1991 amendments. The broad authorizations in these 1991 amendments essentially made this like ANCSA 2.0. These changes were so broad at the time. But in Section 2 of the findings and declaration of the 1991 amendments, it states that the Alaska Native Claims Settlement Act and this act are Indian legislation enacted by Congress pursuant to its plenary authority under the Constitution of the United States to regulate Indian affairs. It's a very clear statement that Congress, wasn't terminating anybody, and they're expanding a recognition of that relationship. So the constitutional plenary authority doctrine is described in Article 1, Section 8, Clause 3. The concatenated version of it is that Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's one of the provisions in the Constitution that provides this plenary authority. Now, ANCSA is not an Indian treaty. Congress ceased ending ceased Indian treaty making in 1871, 100 years before, exactly 100 years before ANCSA was enacted in 1971. The key difference is that Indian treaties required only the participation of the President and the Senate. The Indian treaties were not required, didn't require the participation of the House of Representatives to be binding. Now, the House didn't want to be left out. In 1871, they looked at this and they said, well, they deserve a place at the table because in the Constitution, all appropriations arise in the House of Representatives. And so they had a role in the implementation of these treaties because it costs federal money, to implement them. Even though the original treaties recognized Indian tribes as sovereign and militarily powerful, the Indian treaties, fortunately, always remain bilateral. It recognized that the tribes had a place at the table. It's clear that in the later treaties, the negotiations were literally at the end of a barrel of a gun, and they looked more like adhesion contracts by the time they were over with. But a critical thread that runs through Indian treaties and congressionally authorized Indian land claim settlement is that Congress was required to federally recognize an entity as an Indian tribe as a prerequisite and to be constitutionally sufficient to be able to take these lands. The depth of this federal recognition is not a passing reference. It couldn't be a legal fiction. It had to provide justification. There had to be a claimant owner to the Indian lands being taken, that is an Indian tribe. It makes sense. In 1971, under ANCSA, Congress legislatively adjudicated 365 million acres of lands in Alaska. The legal context of that and the lead up to it was the infamous Teton case. Here, as a Tlingit case, that case held that the Fifth Amendment did not apply to the taking of lands from Indian people. Congress could have taken these lands in 1971 and not paid anything under the doctrine of the Teton. Here's what they said. They said that our conclusion does not uphold the harshness as against tenderness toward Indians, but it leaves with the Congress where it belongs, the policy of Indian gratuities for the termination of Indian occupancy of government-owned lands rather than making compensation for its value a rigid constitutional principle. So the court was basically saying we can take it, don't have to pay for it. It's as simple as that. And the use of gratuities suggested, like a tip. Maybe we have to pay something, we don't have to pay very much. And that's exactly what happened in the Court of Claims. After the Teton case it was a corollary, it had to be also true if the Alaska lands were confiscated from persons other than an Indian tribe, recognized Indian tribe, Fifth Amendment rights would apply to those lands being taken. That is, took lands from a non-native person, it would be a Fifth Amendment taking under the Constitution. Congress has carefully and very precisely recognized tribes in Alaska for the purposes of enacting ANCSA and authorizing a lawsuit against the United States for claims of Indian lands taken from Tlingits and Haidas. In 1935, Congress enacted the Tlingit and Haida Jurisdictional Act. There is clarity in the recognition process that Tlingits and Haidas could not be represented by the Alaska Native Brotherhood and Sisterhood because they were not Indian tribes. So Congress had to have a vehicle to do this, and they did this in the 1935 Jurisdictional Act. And it provides that for the purposes of this act, the Tlingit and Haida Indians of Alaska shall be defined to be all of those Indians of the whole or mixed blood of Tlingit and Haida tribes who are residing in Russian America, now called the Territory of Alaska, in the region known and described as southeastern Alaska, and that goes on from there. The Jurisdictional Act also provided for other common elements of federally recognized tribes at the time. That include the Department of Interior approval of the Tlingit and Haida attorneys, defining who was a member of the tribe by blood, providing for separate offsets for prior settlements, prohibiting per capita payment and others. The Jurisdictional Act offered little doubt that Tlingit and Haida people were recognized as Indian tribes. You can't miss it in the Jurisdictional Act. Therefore, under the Constitution, there was jurisdiction for Congress to adjudicate the taking of Tlingit and Haida lands and define the terms and conditions. And as we all know, it's a lot of land, over 20 million acres in southeastern Alaska. It was equally true that Congress was compelled to recognize Alaska Native tribes sufficient to authorize the settlement of the Alaska Native land claims itself. It did so in several ANCSA sections, the most prominent of which is the definition of an ANCSA regional corporation. It's worth reading that section. It says, for purposes of this section, the state of Alaska shall be divided by the Secretary within 1 year after December 18th, 1971, into 12 regions, with each region composed, as far as practicable, of natives having a common heritage and sharing common interests. So that's an ANCSA, that's the cornerstone. And then it went on to describe the 12 corporations, 12 regions, and then it defined native. It said a native means a citizen of the United States who was a person of 1/4 degree or more Alaska Native, including Tsimshians not enrolled to the Metlakatla Indian community, Eskimo or Indian blood, or combination thereof. It also provided for the recognition of persons of natives in the absence of proof of minimum blood quantum, that they were regarded as Alaska Natives in their community, and it by implication also included adoptees. But ANCSA also provided for the establishment of village and urban corporations. It states that the native residents of each native village entitled to receive lands and benefits under this chapter shall be organized as business for-profit or nonprofit corporations under the laws of the state before the native corporation may receive patent to the lands and benefits under this chapter. But then it went on to define native village. It means any tribe, band, clan, or group, village, community, or association in Alaska listed in section 1610, 1615 of this title, which meets the requirements of this chapter. So if you look at the whole sequence of recognitions, there can be no doubt that Congress was very compelled to recognize Alaska Natives as Indian tribes in order to have this kind of jurisdiction. But what's very interesting, I think important, is that if you look at the language that Congress used in ANCSA, it also appears, the language in section 1606 that I just recited, it uses the language of common heritage and sharing common interests. It happens to be parallel with the language of the Alaska IRA in 1936. And that defines the Indian tribes as groups of Indians in Alaska, not heretofore recognized as bands or tribes, but having a common bond of occupation or association, or residents within a well-defined neighborhood, community, or rural district may organize to adopt constitutions under the IRA. You're looking at that language, you could have easily substituted, under the ANCSA provision for this language, and that's a cornerstone language in the Alaska IRA. So this parallel language, even though it's separated by 35 years, I think it's instructive in how Congress was thinking about Indian tribes for that entire period. So it's evident that in the ANCSA authorizing language that Congress recognizes Alaska Natives as Indian tribes sufficient to constitutionally support an Indian land claims settlement that both transferred lands back to Alaska Natives and that the Alaska Natives agreed that they would disclaim any property interests remaining in Alaska to the federal government and to the state government. So that completes the loop of the logic of how it worked. So in order for the resulting land claims to have severed its constitutional relationship with Alaska Native tribes, it would have had to have formally terminated the relationship. And as I indicated before, there's nothing in ANCSA that uses any of the congressional termination language that was used in the 1950s. So if you look at the Alaska IRA, there are 226 federally recognized tribes. About 70 of them were formally organized under the IRA. The remainder were recognized by a combination of regulatory approval by Assistant Secretary Ada Deer and confirmed in the Tribal List Act of 1994. Both the Alaska IRAs and ANCSA are creatures of Congress. They're both legislation. One cannot know how many federal recognized tribes would have been in existence without the IRA in 1936. Each of the Alaska IRAs and ANCSA are of congressional design, and they provide for very particular kinds of congressional authorized tribal recognition. Both ANCSA and the IRS were established by Congress, each subject to future amendments. ANCSA, as you know, is in a constant state of amendment. Now, it bears thinking about the Alaska model of models in plural of organization and relationship between tribes and the federal government. Congress bifurcated its Alaska Native governance policies with the existence of the side-by-side existence of the ANCSA corporations and the IRAs and other federally recognized tribes. There's little to no evidence that in 1971, Congress planned this structure. It evolved over the last 50 years with the changes in law and policy. The IRAs are federally recognized tribes with a government-to-government relationship as they were established. I have governance over its tribal members, and the Alaska IRA authorized jurisdiction over reservation lands in its original form. But from a practical standpoint, Indian tribes have almost no jurisdiction over Indian reservation because the only Indian country in Alaska is basically Metlakatla, and Metlakatla exists because they specifically asked to be excluded from ANCSA, so they exist as a tribal government and they have their lands as Indian country. But it's important to know about the evolution of this is that the authority to create reservations in Alaska under the IRA was kind of deftly repealed in the FLTMA bill of 1976. So there's really only one exception at this point. Certain Alaska Native tribes have limited tribal jurisdiction over ANCSA Village Corporation lands, as was more recently authorized by the Violence Against Women Act. While the authorized structure of the Alaska IRAs is very similar to the original 1934 IRAs, they operate differently because of the fact that they really have such limited actual jurisdiction over lands because they don't have them. Alaska ANCSA itself was designed to be a repository of Alaska Natives' economic sovereignty. In contrast, ANCSA corporations own over 40 million acres of land. ANCSA corporations have no governmental jurisdiction over its members. And they have not held themselves out as having such governmental jurisdiction over members. Congress directed that Alaska Native lands are to be governed by Alaska ANCSA boards of directors and management, and they are ultimately governed by the annual elections by Alaska Native tribal member shareholders. ANCSA corporations do not claim a government-to-government relationship with the United States in the sense that ANCSA corporations do not have governmental jurisdiction over its tribal member shareholders. That is clear. However, ANCSA corporations have a unique yet federally recognized relationship with the Congress as an Indian tribe under, first, the Constitution, second, under ANCSA and its amendments, and third, under other federal laws that are referenced it. In a sense, ANCSA is the exception to the general model of tribal government in a government-to-government relationship with the Congress and the federal government. ANCSA Corporation have not held themselves out to be governing authorities over people. ANCSA lands are held in fee simple and are not held in trust by the United States on behalf of an Indian tribe. Instead, the ANCSA lands are private lands, but have many congressionally mandated attributes that make them one-of-a-kind private lands in Alaska and the United States generally. The reason is that there are several congressionally authorized private land protections of ANCSA that are unavailable to other landowners in Alaska. For example, undeveloped lands are not subject to taxation, nor they can be subject to claims of bankruptcy under the federal bankruptcy law. The total sum of these land protections does not add up to protections of lands transferred into trust to the federal government, but they are substantial. While Congress created federal law protections to those ANCSA lands, they are nonetheless designated as fee lands. It's technically a misnomer because there's such a substantial congressional intervention that created these authorizations of further native land rights protections. There's little to no evidence that Congress reconciled ANCSA and the IRAs from a public policy perspective. Any of that is, more contemporaneous. Certainly wasn't the case in 1971. However, the resulting entities bifurcated tribal governance from for-profit operations as a practical matter. While Alaska Native tribes recognized on the tribal list are permitted to operate for-profit enterprises, the vast majority of economic resources and tools have been allocated to the ANCSA corporations and under ANCSA and its amendments. ANCSA corporations own over 40 million acres of land, while the tribes own only several thousands of acres. Even if this division of labor between ANCSA corporations and IRAs may not have been planned, may not have been designed by Congress, it does result in some important net positives. The Harvard Project on Indian Economic Development has studied tribal enterprises over the last 20 years, and while there are multiple variables that can account for tribal economic success, the lower the level of interference in profit-making enterprises is a positive contributor to economic success. It helps if tribally owned businesses has significant operational independence as a for-profit enterprise, and that has been documented by the Harvard Project. The largest tribal enterprises, as I've indicated, is Indian gaming, and it's governed by the Indian Gaming Regulatory Act. And coincidentally, this act created quite a level of operational independence for the tribes because they're required to create an Indian Gaming Commission under IGRA, so it's kind of structured in. The ANCSA status as Indian tribe has allowed it to participate in federal economic programs such as the SBA 880 contracting. In fact, ANCSA corporations have sought and they've achieved congressionally authorizations to also purchase radio spectrum and utilize certain federal income law provisions favorable to ANCSA corporations, such as the net operating loss exclusion in 1986. In the case of ANCSA, the principal Alaska Native business enterprises are organized separately from tribal government decisions. So it's important to know what, there's a consequence. The Alaska Business Magazine most recent publication showed the top gross revenue of the 49 largest Alaska corporations. And of those, 28 of the 49 are ANCSA corporations. The top 2 are regional corporations. And very importantly, the 4th one is a village corporation. And there are no federally recognized tribes on this 49er list, in great part because they're governance. They're mostly governance, not enterprise. But there are opportunities for the future out of all of this. The strength of both ANCSA and the Alaska IRAs is that they were congressionally authorized and they're organic. And it means that in both cases, each of them are free to offer amendments to the Alaska delegations in order to fulfill their developing goals. They carry the burden to convince public policymakers that these proposed changes make sense and will bolster each. Also note that both the ANCSA corporations and the Alaska IRAs and the federally recognized tribes were designed to achieve social economic well-being of tribal members and tribal member shareholders. So they have common goals. This means that each seeks benefits for members. There can and there are overlapping goals between the two, and they also can have different priorities. But an important example of this common goal is providing for sufficient customary and traditional hunting and fishing rights for tribal members. Another common priority is to sustain Alaska Native cultures. This is evident in Sealaska's establishment of the Sealaska Heritage Institute that qualifies as a tribal organization under ISDA. The ANCSA Corporation have and will continue to commit money to achieving these goals that do not necessarily add to profitability. The Alaska Native leadership has not necessarily seen these to be in conflict. As a matter of fact, these social economic goals actually are included in the congressional findings of ANCSA itself. It was an important historical moment that the Alaska Native leadership considered legislatively reconciling certain ANCSA Corporation and federally recognized tribal provisions. So this is actually not new. During many of the discussions and drafting of the 1991 amendments, there was an AFN draft, which would have authorized the transfer of ANCSA lands to federally recognized tribes. This was designated as a qualified transfer entity. This review is not to suggest that this be taken up again, as much to show that Alaska Native self-determination has been at work all along. The ANCSA corporations were not the reason why this particular proposal was withdrawn. What may have been good for one era may not be for the next, but it's really up to the Native leadership to consider which structures are best to achieve common goals in the future. Now, Congress has a scope over treaties and land claim settlement, It's evident from reading the treaties and the land and certain land claim settlements that they've all morphed. Even the relatively contemporaneous ANCSA in 1971 and the Maine Land Claim Settlement Act of 1980 shows a high contrast in regard to Indian land claims jurisdiction. For example, ANCSA corporation land ownership is in fee with federal protections. The Maine land claim starts with lands in trust with less jurisdiction over lands than other federally recognized tribes. The state of Alaska role in the governance of ANCSA Corporation is limited to the establishment of the Native corporations themselves and also the implementation, namely the annual meetings and the financial reporting. At the very same time, Congress retained jurisdiction in its statehood disclaimer clause and deferred to what is essentially federal corporate law, where there's a conflict between federal law and the state corporate law. Under the Maine settlement, the state of Maine was essentially authorized to implement their settlement. So you have a whole different deal, very active intervention by the state, less so in Alaska. This is to suggest that Alaska Natives and Maine tribes assert its self-determination, that each will suggest congressional amendments to advance its own social and economic goals in the future. For example, Alaska Natives seek validation and protection of customary and traditional subsistence hunting and fishing on its own lands and public lands. Congress transferred jurisdiction on ANCSA lands to the state of Alaska, while the federal government manages another part of subsistence rights under ANILCA. It's not inconsistent with ANCSA's findings that the land or water jurisdiction and fishing be transferred back to ANCSA corporations on its own ANCSA lands. And it's not inconsistent with tribal lands jurisdiction in the same sense that there is joint jurisdiction on lands between local government and state government and their boundaries. In Indian law, this is especially the case because with the implementation of Public Law 280, in which Congress authorized the state to have both exclusive and concurrent civil and criminal jurisdiction over certain Indian reservations. And Alaska is a PL80 state, and so this is not a new concept of sharing jurisdiction. And finally, the Congress reserved its right over Alaska Native property located in Alaska, including lands in the Alaska Statehood Act in 1959 and the parallel disclaimer clause in the Alaska Constitution itself in Article 12, Section 12. It bears reading. It says that the state of Alaska and its people forever disclaim all right, title in or any property belonging to the United States or subject to its disposition and not granted or confirmed to the state or its political subdivisions by or under an act admitting Alaska to the Union. The state and its people further disclaim all right or title in any property, including fishing rights, the right of which may be held by or for Indian, Eskimo, Aleut, or community thereof, as that right or title is defined in the Act of Admission. The state of Alaska and its people agree that unless otherwise provided by Congress, the property as described in this section shall remain subject to the absolute disposition of the United States. That is, they further agree that no taxes will be imposed upon any such property until otherwise provided by Congress. This tax exemption shall not apply to property held by individuals in fee without restrictions on alienation. So Congress has great latitude to reconceptualize both ANCSA and the IRAs, including Alaska Native jurisdictions. In some greater sense, it's up to this generation of Alaska Native leadership to seek innovative solutions. It's my view that it's really a question of imagination, development of a strategic plan, allocation of the necessary resources to accomplish it, and having the fortitude of prior generations of Alaska Native leaderships to get the job done. Thank you very much. I appreciate your time.
Thank you, Chris. We can open it up for questions from the audience or online.
Chris, thank you very much. Unbelievable. I mean, Indian law is so complex, Alaska Native law is so complex, and my head is just swirling with all kinds of things that you've talked about. And it's really clear that, you know, what you've presented, you know, is something that we really need to understand and study. And in listening to you talk, I said, oh, how can we do this? First of all, we are going to publish this lecture. It'll be published in the Box of Knowledge series. But what I'm thinking is we need to have almost lectures on various components of it. But anyway, one of the things that I was thinking about, I mean, I was taken with your statement that both ANCSA, corporations and tribes, or the IRAs, are creatures of Congress. They created those things. But what happened behind that was Native people also wanting things. I mean, it was Native people who wanted not necessarily corporations, but the control and ownership of their land. They had the benefit of the experience of the IRA corporations where DC bureaucrats would make decisions about fish nets or boats and what fishermen could buy. And they didn't want to have that kind of oversight, Native people ourselves. And then Native people themselves were Alaska Native people were the ones who lobbied to have the IRA extended to Alaska. And I can't recall if it's just all of it or if it was the economic provision that they lobbied for. But I know it was A and B.
It was the whole thing.
It was the whole thing.
They just wanted to make it apply to Alaska.
Yeah.
What didn't fit.
Yes. So a lot of the things, you know, came as a result of what we wanted also. But I also know that Congress sounds like I'm giving a lecture too. But Congress wanted corporations for very different reasons. We wanted control and ownership of land. Congress wanted assimilation. But the issue of corporations itself, it just keeps bubbling up as, you know, as a conflict area, a source of conflict, corporations. And it seems to me from what you're saying is that the opposition from the tribes in the lower 48 centers on money. Mm-hmm. Are there other reasons?
Actually, no, I think it's both. I think definitely the money under the CARES Act. I think that there was a thought that, you know, Alaska Natives would take a big part of the CARES Act money, which of course didn't turn out to be the case at all. But money did motivate it. But I do think there is a sentiment among some tribal leaders that the structure of the Native corporation is just wrong. It's not something that, you know, should be, you know, allowed, and with a very strong preference for the Alaska Native tribes. I think it's very important. What you brought up is very significant insofar as how did these provisions of land and fee rather than reservation occurred? Well, you know, you just have to be old enough to have experienced, you know, the domineering attitude of the Bureau of Indian Affairs. So the leadership in 1971, I think, is simple as they wanted to fire him. They wanted him out. And if you look at the structure of ANCSA, that's exactly what they did. Because the only role that they have, ongoing role, the role that they had was to create the role, the Native role, and to approve the first articles of incorporation. After that, the BIA didn't have a role in the implementation of ANCSA. Was only other federal agencies that, like the BLM, that had a role in asserting other people's rights, like 17B easements, for example. So they didn't have a role in governance.
The other thing is, I know it was Native people themselves that wanted Native corporations, and then they began to understand the flaws of ANCSA, and, with the 1991 legislation, or the 1987, I guess, legislation, but we called it 1991. And I thought it was phenomenal that Native people met in 5 statewide meetings trying to talk about what were the flaws of ANCSA and what did they want to, how did they want it changed. And they got things like land banks. I mean, that was what Native people got. The other one was the right to enroll children born after 1971. But the other interesting one to me was the QTE that you mentioned. And where Native people said, yeah, let's transfer lands to tribes. But what happened was, I guess, our congressional delegation didn't support it and put in a lot of qualifications that would have undermined tribal sovereignty. And maybe that's something that we need to go back and look at again, maybe that would alleviate some of the conflicts that we continue to have between Native corporations and tribes. But I know this is a lot of work, but I think I'll end it from there and see if there are any other questions.
But I think, both your experience and mine during those negotiations and discussions, that there was not an opposition from the ANCSA corporations to this provision. It was like, it's another opportunity, was regarded as another possibility. As you've indicated, it was the delegation that didn't like it, because Senator Stevens in particular, had authorship over ANCSA and may have seen this as sort of taking it apart in a way when it wasn't. But it was an opinion. Yes.
We have a question online from Nancy Barnes. She says, "Hi, Chris. What do you think the implications of Native programs such as IHS, subsistence, Native education, housing, tribal funds, jurisdiction, etc., are with the new presidential administration?"
Wow, that's loaded. Well, I kind of demur on that one. It's like it remains to be seen, because first of all, the Native communities can be very active. It'll be up to the Native leadership to figure out what it wants from the administration. Native corporations and Alaska Native tribes are quite activist. If there are bumps in the road, I think there will be a very strong interplay between the administration, the Congress, and the Native community.
Okay. Well, thank you very much for sharing your lecture with us today. Our next lecture will be Tuesday, November 19th, this upcoming Tuesday, with Dick Trudell, and that lecture will be virtual only. Thank you again, Chris, for sharing your time with us.
And thank you. I really appreciate the time.